Okay, it looks like we're live now.
A tired old man. Thumbs up. Good morning, ladies and gentlemen. This is the September 27, 2017 briefing session of the Utah Board of Oil, Gas, and Mining. We'll turn the time over to you, Director Baza.
Thank you, Mr. Chairman and members of the board. Welcome back to your meeting in Salt Lake City. And my name is John Baza. I'm the Director of the Division of Oil, Gas, and Mining. And we've prepared for you a couple of items to discuss on your briefing schedule this morning. First of which is discussing our October field trip. And Dana Dean apologizes that she is not here today. She is participating in a Department of Natural Resources field trip that's down in Cedar City. They went and viewed some of the results of the Bryan Head fire and are looking at other natural resources issues down in that part of the world. She should be back tonight, but she has been working with Compass Minerals, and I think you'll remember it was Earth Day Awards in 2016 that the board recognized them as a best of the best in terms of an Earth Day Award for that year, and that was because of the work they were doing in mineral extraction and reclamation out in the Great Salt Lake. So she has talked to them, and the day prior to our October board meeting, which I think is scheduled for October 24th, if I'm not mistaken. The day before that, we would be going on a field trip, leaving from here, going up to their facility out west of Ogden. So we would leave the DNR building at 7:30 that morning, arrive at their facility around 8:30. We'll sign in and have a presentation. And then at 9:30, we would get into some vehicles for a driving plant tour and some of the closer dikes. And I think they wanted to take us all the way up to Promontory Point through their property. So that will probably take a couple of hours at least. So we think that we'll be headed back to DNR sometime between 11:30 and noon. So it would only take about half a day, and you'd be back that afternoon for any business you need to attend to. Then the next day, of course, will be our board hearing here in Salt Lake City. So if that sounds good to you, we'll go ahead and confirm all those arrangements, and we'll make sure that there's adequate vehicle space for traveling up there. And apparently there's no special safety gear needed for the plant portion of the tour, so we'll be in vehicles during that whole time. If we want to stay there longer, he has indicated we could go farther out along the causeway and the dikes, but that's kind of up for us to decide, and we can certainly even let him know that day if that's something we want to do. So do you have any questions about that at this point?
Board members, any questions? Seeing none, I think that would be a great idea.
Okay, wonderful. Our second item on the briefing agenda is to talk about a letter that the board received from the legislature regarding the Commission for Stewardship of Public Lands. And I thought I would start out with that. We may hear more from our attorneys in just a second, but what I wanted to say about that was this kind of all initiated back in the legislative session of 2016 when a numbered House Bill 276 was passed by the legislature, and it was called the Utah Public Land Management Act. They amended that act a little bit in the 2017 legislative general session just to clarify some language. But in House Bill 276, there were some lines in that bill, and I'll quote from it. It says, "The director shall, by October 30th of 2016, report to the Commission for the Stewardship of Public Lands regarding the division's recommendations for how the state shall deal with oil, gas, and mining issues in the Utah Public Land Management Act." In response to that, we sent a letter to the Commission on October 28th, 2 days before our deadline. We were never clear as to whether we needed to appear before the Commission or if a letter was going to be adequate, so we chose to just send in a letter and wait to hear back from them. It took them several months, I think, before they came back to that issue, because they invited me to come and present to them at their July 2017 meeting. And if you go out to the legislative website and find the Commission for Stewardship of Public Lands, you'll see that they have a presentation by me as well as our response letter posted on the legislative website. But during that presentation, I indicated that the division had some recommendations, 4 recommendations in fact, regarding the requirement indicated in that statute. Our key recommendations, and it was entirely based on a proposed land transfer from the federal government to the state of Utah. And I think there was basically a minimum requirement on that. So you had to have so many hundreds of thousands of acres of transfer before the provisions of the Public Lands Management Act at the state level would kick in. So our first recommendation as part of that was to allow a transition period for retooling of OGM's computerized database to accommodate the large amount of information and the format that we would acquire from the BLM if there was a transfer of ownership. Also, we would allow the transition period for coordinated information transfer between us and the BLM staff. The BLM has 11 field offices, 4 district offices, and then their state office in the state of Utah. So we would have a lot of dialogue and conversation with those offices in order to make sure that we were doing things properly. So again, if a land transfer occurred in that minimum requirement, we would first of all recommend that there would be a transition period before the provisions of the Land Management Act would kick in. Number 2 was that we would expect that documents, orders, or directives regarding land transfer should identify and clarify the application of other federal land management laws and requirements, things such as NEPA or the Endangered Species Act. How would those things apply as part of this land transfer? Some of those things already do apply on federal land within the state, but we would want to know if there's a land transfer, how would those other federal laws be applicable? Our third recommendation was that we should allow for funding of these new responsibilities on land that is transferred. It's realistic to believe that we couldn't do it for free. There would probably have to be a staffing up. We would probably have to ensure that appropriate state funding and appropriation was made. And the funding should include, again, the transitional period for ramping up our regulatory functions to a full transfer. Because obviously we're not just going to be able to go out and hire a bunch of people immediately for this purpose. It would take some time to do that. And then our fourth recommendation is we might want to consider a pilot project of just a small scale land transfer to debug the process before we go to a full land transfer. Now, those were the 4 recommendations that we turned into them. I gave that verbal report to them on July 27th. And apparently, and I didn't stay around for the whole meeting, but there was a motion made to task the division to answer certain questions. So that was the nature of the letter that you as board members received on October 24th, and that should be part of your packet today. And if you've read that letter, it basically says that the Commission for Stewardship for Public Lands received my presentation and the recommendations, and it says, while the Commission fully supports such a transfer until it occurs, we recognize an opportunity for the state to play a larger role in the management of lands within its borders, particularly regarding DOGM's minerals programs. And there are 3 bullets that they asked us to undertake. They wanted to address research and investigation into the current policies under which mineral leasing money is administered. The second was how policies, regulations, and laws, including the 1920 Mineral Leasing Act and the 1977 Surface Mining Control and Reclamation Act, have impacted jurisdiction and management over minerals. And thirdly, the legal issues associated with and resources that would be required for DOGM assuming all federal responsibilities over minerals programs. Now, you can probably see that this is a very broad request and covers a lot of ground. We may have to dialogue with the Commission a bit more to clarify what these specific issues they want us to look at, because some of this stuff has been studied for many years by different parties. Finally, the letter says it would be our preference that DOGM completes this report before the 2018 legislative session, and we can invite you to attend a future Commission meeting to present and discuss the findings. So we do have questions. We do have some scratching of heads we need to do over this. So we'll have to dialogue more with the Commission staff and find out if there's more information that we can gather from that. Beyond that, I think I'm going to need a lot of help from our attorneys, because a lot of this is legal interpretation of previous laws and statutes. So Steve or Emma, do you want to take some time and comment on this? Probably introduce yourselves, Joe.
Thank you, Mr. Baza. Good morning, Mr. Chairman and members of the board. I'm Emma Whitaker. I'm a new O'Hara Fellow and new attorney with the division, so I'm excited to be here. So we just wanted to give you an update on what we've done with the letter so far. So we've done an initial review of the literature. There's quite a bit of studies out there done by either the University of Utah or at the direction of the Utah Public Lands Policy Coordinating Office. So as you can see, responding to this request is going to take a lot of time. It's a large research project. There's several different agencies involved and different levels of regulation. So it's going to take some time to dig through relevant information. So as Mr. Baza said, we feel as if the questions presented in the letter are quite broad and lacking specificity. We were able to talk to Miss Ruth Ann Frost with the commission last night. She was able to give us some clarifying information. And the requests are given assuming that the lands actually aren't transferred to the state, and asking what role the state would play in the event of that. If you have any comments or suggestions, we'd appreciate your guidance. And we'd also be happy to answer any questions.
Board members, I was involved in 3 major land transfers from the federal government to the state of Utah, dealing with, one was the Drunkard's Wash, the other was out of the Forest Service Arches, Canyonlands, and Dinosaur. And it might be a good idea to talk to Sitla about their experience in those lands transfers. That doesn't affect your jurisdiction to a great degree, but it might give you some ideas about how that was kind of pilot projects, if you will, because it was a 400,000 acres each time. But it didn't affect mining. It was mostly, so you had the Magnum Resources Salt Dome, you had the, which was the only, I think, mining one I can think of. You didn't have a lot of coal involved. You had coal bed methane, but having said that, it still might be something that might be worth examining.
Thank you.
Comments on that? And then it might be, we've got, at least as to mining and SMACRA and things like that, we have 3 experts on the board and hard rock mining that might very well provide you some easy macroeconomic 40,000-foot look at some of this stuff that might point you in a easier direction or help in some way. So to the extent the board can be of assistance, I'm volunteering I'm volunteering their time.
I wonder if the transfer of Sitla lands out of the Grand Staircase Escalante process that they went through.
If that couldn't have been more fouled up. What happened on that was that the land transfer was basically a done deal. It was signed by, I believe it was signed by the state, and was waiting for a couple of initials on the federal level, and then was to be signed. And then the Clinton administration came in and kind of didn't tell anybody and set up the Grand Staircase Escalante on an overnight deal and changed all that in just a real difficult time. The state sued the federal government, immediately noticed up the deposition of Al Gore, and within 2 weeks we had a settlement proposal. So there are some lessons to be learned on how to do that. And but anyway, the end result was the Drunkard's Wash transfer, which still would be a good pilot project to look at, but it's
Several coal tracks that from the BLM to Sitla, part of the settlement, and how that was accomplished might be.
yeah.
Mr. Chairman, if I might.
Yeah, you need to speak into the microphone. I
Okay,
challenge
sorry.
everybody to do that. Go ahead.
Mr. Chairman, if I might just comment, Steve Alder with the division's attorney with the Attorney General's office. We've looked at this. Initially, it appeared that the letter was in the context of anticipating transfer of title, as you've just mentioned with these exchanges. And we were aware that there have been a lot of studies by PLIPCO of the consequences and how that would be accomplished and what laws would, how the laws would need to be amended or interfaced. And so we were a little puzzled as to what more we could do. So it was just in reaching out to the attorneys for the commission that we finally understood that they kind of changed direction, and maybe perhaps in response to Mr. Boz's 4-step plan, where one of them was do a pilot project and kind of lay out the beginnings. So their request, as we understand it now in this letter to you, is let's assume that these lands never get transferred. What can the state do to manage minerals under the federal? How can the state take over the federal management role? So in other words, can the state issue federal APDs? Can the state do federal leases for oil and gas? Can the feds administer mining permits for the BLM? And that will be, I don't think that's been looked at very much. The other research that's been done will be helpful, but rather than assume that federal responsibilities are transferred to the state, it will require that we evaluate how the state can assume some of those responsibilities under an MOU or a contract, and which of those responsibilities are assumable and which are not. So frankly, it's kind of daunting to me to get this done in time for the legislature, but that's the nature of the task. It's just so you understand. It's slightly different. We have been told that the PLIPCO people can help us out on this, and we certainly welcome your input, and we'll be talking to you, because I think the information that was gathered through these exchanges, I'm familiar with that a little bit, you know, how to accommodate cultural resource protection at the federal level, all those things will be helpful. But anyway, if that helps clarify the nature of this.
Yeah, you're also involved in some of those. Weren't you at the settle at that time?
I think we both were in the same office at one
Yeah,
time down there.
okay.
Yes. All right.
Well, thank you very much. Back to you, Director Baza.
Well, thank you for the opportunity to talk to you about that. It's the first board hearing we've had since the letter was sent out at the end of August, so we felt it was important to try to inform you how far we've come in the last month. And as Steve said, it's a big hill to climb to be ready for the coming legislative session.
If last board meeting, we had a short discussion on the board's role in policy. To the extent that you feel like there are some policy decisions that the division is going to make or recommend, and you would like our assistance on that, please let us know.
All right. Well, we always rely on the board to help set our course as far as regulation of oil and gas and mining in the state of Utah. So I'm sure we would appreciate any help you or the board's attorney could give us.
Okay. Board members? Down in the back of your mind.
Okay.
Okay.
The third item on our briefing schedule this morning is just to present to you some proposed hearing dates for calendar year 2018. This is just for you to digest and compare these dates with what's significant on your calendars. And then we would not take an official decision by you until next month at the October board hearing.
Board members, any comments or questions? I have one. I have a conflict on both January hearings that are on in 2018 and 2019. And I'm at the next board meeting, I'm going to recommend that we move those hearing dates back 1 week. And I don't think that would affect much. You will not be able to? Just how many of those years? Both of them? 20.
Haven't scheduled anything for 2019 yet.
And that's what we'll just, so keep that in mind, and we'll discuss that.
We can sure take a look at moving that date forward or backward. And
Forward is a little difficult, I understand, and but backwards 1 week. Anyway, we'll talk about that more, but just keep that in mind, and we'll go from there. Other than that, I don't have any concerns about it.
okay, well, go ahead and take a look at that. Please give us your comments, and Julianne will certainly try to do her best to accommodate schedules.
Thank you very much.
I have a couple of other items to mention to you that have come up recently. First of all, you met Emma Whitaker, one of our O'Hara fellows, and James Owen have both recently passed the bar exam. So congratulations go to each of them.
Hear, hear.
Yes. And I think you know James from his discussions with you in the past on the rulemaking matter. So They are both, I guess, official members of the bar in the state of Utah.
Welcome to the club.
Yeah. Second item that I'll comment on, it is not too early for the board to be considering what you might want to do for a holiday social this year. The last 2 years, we've always scheduled our holiday social in this same suite of rooms immediately following the board hearing in December. We can continue to do that, or if you have other thoughts that you would want us to consider, we can start making those plans. But we'd appreciate your input on that to decide what needs to be done.
Let's talk about that for a minute, board members. We've had a joint party with the board and the staff in the past, and then the last 2 years we've had this open house here right after the board hearing, which has allowed the public and practitioners to come to that. A lot of good dialogue and so do you have any thoughts or how you would like that to proceed?
I thought it was fine.
I really enjoyed the open house. I thought it was really worthwhile to talk to some of the folks, and I'd like to see more of the company representatives be here, but I thought it was really good.
And we've usually established a pretty inclusive invite list in legislators,
Yeah.
people on the Hill, whoever wants to come. So,
And you had a couple of other division heads that,
right.
or department heads that came that was also good.
So if that's acceptable to you, we'll start planning in that direction. And if you want to change your minds, please let us know.
I doubt we'll to change our minds, so why don't you start in that direction?
Okay. On the calendar, the last thing I'll bring up is there is a collaborative meeting scheduled out in Duchesne on the 12th of October. It is going to be a discussion of John Rogers is going to give kind of an update of recent activities within the division. We're going to talk about the updated division database, as well as I think one other presentation. But again, you're invited to attend. We've often gone out the same day and just made it a day trip. That makes it a very early morning because it takes about 2 hours to get there for a 9 o'clock meeting. There's a possibility some of the folks will want to go out the night before and spend the night, but you're certainly welcome to attend that.
If you haven't attended that, these are really good meetings. Unfortunately, John, I'm going to be flying back in that day.
Okay.
And so I'm not going to be able to make it, but I'd like to be included in the future ones. It would also like to have at least, I know, Gordon, you're in the area. You might go.
I'll make the quarter-mile trek over to the convention center. I'll be there.
Okay, and then, but yeah, these are really informative meetings. You get a chance to talk to the folks in the trenches and on the ground, and it's really would recommend those for your consideration.
We've called it our oil and gas operators meeting because we generally get anywhere from 50 to 100 people attending the meetings over the years.
And then also, the new Duchesne Convention Center is really something to see, and it's been very well thought out, and it's a really nice facility. If you haven't seen it, this is another opportunity. So I'm trying to encourage you to go if you can't tell.
Thank you, Mr. Chairman. The last thing I'll mention before I turn it back to the board and whatever else you want to do today is I have to depart for some out-of-state meetings around noon today, so I'll be staying with the board this morning for your morning session, but I'll have to leave at noon. So appreciate all of your support.
We appreciate you, John, and I think I speak on behalf of all the board members on how much we appreciate what you've done and how you've elevated the state of Utah among our sister states in prominence and credibility, and you know, it's a pleasure working with you. Thank you
Thank
very
you.
much. Any other board members want to say anything, or any other issues that you'd like to discuss? Okay, seeing none, we have next month's agenda. Do you want to talk about that at all?
Sure, yeah, that'd be great. Right now, obviously, the briefing schedule is pretty meager. We generally populate that within the month prior to the board meeting. But the matters that are on the formal agenda include a continuing, I think this is a continuing item from Axia. Am I wrong, or is that a new one? Okay. And Ultra Resources is another matter. Ultra should be interesting. It's a water flood operation out in Uintah County. We have Finley Resources requesting a hearing to establish drilling units for hydrocarbons, also out in Uintah County. And then we have New Field Production discussing some stand-up vertical 1280-acre drilling units. So those will be related to horizontal drilling.
Okay.
I might mention that, you know, we've seen quite a few of these horizontal drilling spacing activities in the past few years. You know, I think the school of thought out there is there's some folks who are still very much aligned with vertical drilling. And I was at the Uintah Basin Energy Summit last month, and they came up with this new analogy that for the formations out there, rather than calling it potato chips or pancakes, the guy compared it to a tiramisu, layer cake type of activity, to a jelly donut. And he says the tiramisu is very amenable to horizontal development. So I think we're going to see a lot more of this come about. And there are some schools of thought out there who think that horizontal really is the only way to go in the future. But I think we still have a lot of traditionalists who are suggesting that vertical drilling is still what they want to invest their money in. So we'll see a lot more of this as time goes on.
I wonder if there's I know you've got your lawyers all tied up with answering the legislature, but you know, we had the pilot projects for horizontal drilling, the 7 pilot projects. Newfield took 4, I think Crescent Point took 2, and Whiting took 1. And we've done all, I think most of those have been done under kind of a pilot project idea. I wonder if it would be worthwhile, and I'm not asking you to do this, I'm just asking you to think about it and then maybe come back and say, we've thought about it, this might be a good idea, or it's premature. Would be, what are the lessons learned from your perspective on all of this? Are there any policy or issues that we ought to be thinking about? You know, in North Dakota, for example, they made a policy issue that all of the 2-mile spacing units for horizontal drilling would be north-south because their fracture orientation is optimized by north-south. I mean, the fractures are north-south in essence. Ours are you know, 10 o'clock, 4 o'clock, and I think in one case more toward 9 to 3. And so we're looking at you know, stand-ups normally are north to south, but there might be occasions when it is east to west, and so.
Axia is drilling some right now, east to west.
Yeah, and you know, as far as I'm concerned, I still feel like we're in the pilot project stage, and so you know, there might be an interim report. What did we learn from that, or how much longer would it probably take, a year or 2 to really get our hands around all the issues involved? I still feel like I'm learning every board meeting, just on the policy side of it, you know,
Sure.
and then the difficulty of vertical drilling and horizontal drilling in the same spacing unit is something I still haven't got my head around and I'm struggling with. So,
Well, let us have a chance to review that and go over some of those old board decisions, and I think we could come back in the next couple of months and
if
give you
only if it's ripe, you know,
Right.
just to do it is, and it hasn't matured enough is not what. Let's let it mature. But if in a couple of months you feel like that's matured enough to at least some preliminary discussions or ideas, that would be appreciated.
Well, one of the things that has concerned me is the horizontal drilling rule that we have right now was designed clear back in the 1980s, and it was when vertical drilling was really the thing to do and horizontal was just experimental. So I think it probably behooves us to take a good look at that and see if there's not something we could do that would craft a rule for horizontal drilling statewide. And, you know, it might have to be overly broad, but at least we would have something in place where operators would, as you've mentioned in the past, know the rules of the game.
Yeah, before they play. Yeah, it's interesting. Those rules only allow 1 mile horizontal well, so yeah, that would be an interesting thing. Thank you. I have another point. When does your survey of customer survey close?
We ran that starting in mid-August. I think it should have closed mid-September. Holly Brown is still doing some field work, but I haven't had a chance to talk to her to see
We're
the
always
results of
interested in that, and
Right.
and I'll, you know, for not only the number, but from the lessons learned or comments made or ways in which we can be either more effective or more efficient
Right.
in what we're doing. And then the final, just a personal comment, if you will. The budget process is starting. I would like to express from the board's perspective, at least my perspective, how much it has helped us to have this audio visual. And we see it transition from the first hearing up to remote testimony up to where we are today. And I think it's important for the decision makers to know how much it has helped us perform our duties and give it a, you know, that's out of your budget, but I think they need to know that it is, not only is it a convenience, of course it is that, but it is an effective tool. I think it has helped us examine a lot of the exhibits. It's helped people in the audience. It's remote. It's more transparent. I mean, there's a lot of good reasons to say it, but I think, you know, board members, I hope you support what I'm saying here, but I think it's a very, very useful and important. It's become more than a convenience to a necessary tool, particularly in the remote testimony. And anyone else want to comment on that, or have I said it appropriately? But I think it would be, I think, to pass that along to those that do control that budget would be appreciated.
I will do so.
Thank you. Okay, is that anything else?
I'll turn the time back to you, Mr. Chairman.
Thank you very much. Okay, this is the time for anyone in the audience that has a issue within our jurisdiction that you'd like to address with the board. Yes, please come forward. We're going to ask you to come sit right here in front of the mic and introduce yourself and who you represent and your address, please, sir.
Sure.
And then our sound system is such, and recording system, we need you to speak almost touching the mic.
Without biting it.
Without biting it, yes, thank you.
I'm Terry Marasco, and I speak to many groups on the ground, environmental groups, community activists, but I speak for Utah Moms for Clean Air. And I'm here as I was a few months ago on the Kennecott lack of a bond. I've been emailing, have a thread with Meg Oswald. And the final question I asked her after pages of emails, do you know if in fact Kennecott has submitted to this board, and the question is also for each of you, any financial information to substantiate whether or not, if they close the mine, they have enough money to pay for mitigation? So she couldn't answer that question. I assume she doesn't know. I assume the board doesn't know. Does anyone on the board know if Kennecott has submitted, since its contract, since its handshake in the 70s, any financial information to substantiate that they could pay for mitigation?
Board members? We don't have the board member that's with Kennecott to respond perhaps for Kennecott, but I do know it's part of the obligation that they provide that financial information, and I know it's something that has been discussed on past occasions in terms of what that's done, but I don't know the answer to that.
Okay, so therein lies the problem. So if that's their obligation, as you stated, and you haven't had any, the position that I speak to for the citizens and taxpayers, we don't want to end up with that liability. So here are some scenarios. So let's assume Kennecott gives you a piece of paper that says we have the ability to pay. And you look at that piece of paper and you accept it. That wouldn't be acceptable to the public because a piece of paper from a copy shop does not pay for maybe hundreds of $millions of mitigation costs. So I'm still saying that you need to insist that Kennecott comes up with the surety bond. And I think there's an example that I think is on your agenda that I saw about an oil company that has a surety bond, and there's an oil well to be either abandoned, and if they didn't have the bond, the state would have to plug it up or something like that. But that's just a small piece. So if we're talking many, many millions of the largest open pit mine in the world, I just don't want to see us, me as a taxpayer and the rest of the taxpayers in Utah. I forgot to give you my address. I live at 260 South and 500 East, Salt Lake City, 84102, I think the zip code is. Just a quick question, a comment on the transfer discussion, which is your jurisdiction. I would suggest the board ask the attorneys that if there's any land transfer at all, this hypothetical land transfer, will Utah be responsible to pay back any money that was exchanged with the federal government for past transfers or whatever? And there may be some huge liabilities there because I had seen some questions floating around town as to whether or not, if this ever happens, is there any financial liability back from Utah? And that's, I'm not an attorney, so I'm suggesting the board discuss that with your attorneys in doing your research. That might be a possibility. I've just heard some things. I think that's it. Thank you.
Thank you very much. Board members, any questions?
Sorry. Good.
Okay, thank you for your comments. We appreciate that. Okay, then, anyone else? Seeing none, then we are going to take a break and we'll be back about 9 o'clock. Thank you. Oh, just so you know, we are going to have a working lunch today. Carl, can you make that? Okay, we're going to have a working lunch, and then I'd like to talk to you guys for just a minute. So with that, we will be in a short recess. Short break.